I'll turn first to Ms. Cott. Are we ready to go back on the record?
Well, I have one clarifying question. I've been
Great.
able to find everything else, but I want to make sure I get this right. It's for Ms. Willie, and she says she's currently working out of Sacramento on, and forgive my mispronunciation, this is what I heard, Mucinot and Miwok lands. If I could get a clarification on that.
Please, and I remember that. I think you introduced yourself, Ms. Willie. Let's see if she's joined us.
Yes,
Yes.
it's Nisanon. Let me
Yeah,
see.
how do you spell that?
N-E-I.
I'm sorry, one more time?
1 second.
Okay.
N-I.
M as in Mary? Or
N.
Nancy. Okay.
Nancy, yeah.
N-I.
S-E-N-A-N.
Nisenan. And then is it Miwok, M-I-W-O-K? Or did I get that wrong too?
Yes, that's correct.
Okay. On Nisanan and Miwok lands. Okay, well, I'm glad I asked because I don't think I would have found that. With that, I am ready to go.
Thank you. And thank you, Ms. Willie. I'll go ahead and orient us. Welcome back. It's the afternoon of September 23rd. I am Nicole Kinsey, the presiding hearing officer for the Administrative Hearings Office of the State Water Board. And this is the hearing with respect to the pending applications and petitions of the Sites Project Authority with respect to the proposed Sites Reservoir. We're joined here today with Board Member Morgan, who is pinned with us up on YouTube and our streaming. And where we left off was with our panel 9, and Ms. Willie was conducting cross-examination, and I believe is in the middle of her cross-examination. So with that, I will turn things back to you, Ms. Willie.
Thank you, and welcome, Board Member Morgan. Thank you for being here. So I just want to backtrack a little bit from where I stopped. But if we could bring up Ms. Forsythe's testimony, specifically, let's see, page 21, paragraph 77. Thank you. And Ms. Forsythe, I just wanted to confirm something regarding the timeline or the time that the notification letters were sent for the draft EIR recirculation. Can you confirm that these notification letters were sent out during the COVID-19 pandemic of 2020?
I don't know the specific time that the governor had declared the COVID-19 pandemic, but I believe that this time frame does overlap with that. And that is consistent with the fact that we held our draft EIR or revised draft EIR public meetings. Oh wait, no, this was 2020 timeframe. That was later. I believe that this was around that time frame. I don't remember the specific time that the pandemic notification was in place.
Mm-hmm. And so if you remember, was that taken into consideration when notice was sent to these tribes?
We definitely did think about that. At that time, we were still working with quite a bit with Yochidehi on a remote platform and having Microsoft Teams calls on a pretty regular basis with Yochidehi. And we did think about, I mean, of course, there was a lot changing in the world at that time. So yes, we thought about what the pandemic may mean to the tribes and their ability to participate.
Thank you. Okay, now moving to page 23. Or actually. Oh yeah, page 23, paragraph 81. So here you state the cultural resources report was sent to the consulting tribes Yochadihe and Cachaldihe. But prior to this, United Auburn Indian Community had requested the opportunity to review the cultural resources report. Why was it that they were not?
Yeah, we had a lot of discussions on the request from United Auburn. And in those discussions, we wanted to be very careful to respect the confidentiality of the resources that are described in the cultural resources report. And we're a little bit concerned about sending that to United Auburn because we did not understand them to have traditional or cultural affiliation with the project footprint specifically. So what we did is we reached out after internal discussions, we reached out to Yochadehi and discussed this request with Yochadehi. And our contact at Yochadehi at that time verbally told us that his preference was that we not send United Auburn the cultural resources report and that he would contact them directly. And I believe that some of that correspondence may be in sites 095. Yes, it is in sites 095. I'm looking at some of it on page 352.
Thank you. And then if you could scroll down to lines 13 and 15 through 15. Thank you. Here you mentioned that Cachaldihe sent a letter deferring consultation and communication to Yochadihe. And in this letter, I'm going to quote the letter. It cites 99 on page 107. At this time, we do not have the capacity to consult on this project, but respectfully ask that you defer all correspondence on this project to Yochadihe Wintu Nation. Reading this out, was it understood that Cachaldihe was deferring all consultation to Yochadihe or just communications?
I think you may have the wrong line references
Okay.
here. And I couldn't quite find that attachment on the page that you mentioned, but I can speak to this irregardless. In that letter, it was the site's authorities understanding that that deferral was solely for that specific geotechnical activity.
Okay. Sorry about that. Thank you.
That's okay.
And then if you could go to paragraph 84, please. Thank you. So here you note that there was further notification sent out in February of 2022 and that no other tribes aside from Yochadihe responded to this letter. Is that correct?
Let me just refresh my memory here.
Yeah, I'm gonna object as vague. I
It's,
I think we need some clarification. I'm a little confused now with the testimony. We're looking at paragraph 84. Is that correct, Ms. Willie?
yes, just confirming line 21 to 22. That no other tribes responded to the February notification letter.
So in this context, paragraphs 83 and 84 need to be read together. I think your prior question was actually on paragraph 83, about Kachel response. So in this, for the 2022 to 2024 geotechnical activities, both Yochadehi and Kachel responded. Kachel had the response that deferred their consultation to and communications to Yochadehi. Yochadehi requested consultation. No other tribes responded to that 2022 to 2024 geotechnical efforts.
Okay. Thank you for clarifying that. Sorry for that. And for that notification, there was just one singular attempt to reach these the tribes regarding these investigations.
I would need to, sorry, I'm just looking to see if I could take a look at the record very quickly. I would need to take a look carefully at sites 95 to answer that question, and I just don't see the info right offhand to do that quickly.
That's fine, thank you. We can move on. Can you move on to paragraph 85, please? And so for this the final 2022 to 2024 post-review discovery plan, which was sent to Yocha and Kachil why was that not sent to other tribes?
That is because we were originally in consultation with Yocha for AB 52 consultation for the 2022 to 2024 geotechnical activities. Kachil subsequently expressed interest in those geotechnical activities, so we started to send them information around those. And frankly, they had done geotechnical monitoring for us in the past. And so we had started to send them information around these two, around both of our geotechnical activities that were ongoing from the 2022 to 2024 timeframe. The other three tribes with traditional cultural affiliation with a project footprint really had not expressed interest in any of this, so we had not sent it to them. I will say, well, at some point in time, and I can't remember quite where, and I might have it in my testimony, but Paskenta also started expressing interest. Danielle, we just, for the geotech, it has just been Yocha and Kachil because we haven't done geotech work in Glenn County. We haven't sent materials yet to Paskenta on geotech, if I recall correctly.
I think that's correct, Dolly.
But this was a final report, not something that you were requiring input or consultation for from those tribes.
I think I can answer that if you want, Ali. It's really our like our monitoring plan, and we do welcome input on those that they're kind of living documents as we go through, monitoring and post-review processes, and we like to refine those as we go.
And so was the reason then that you sent it only to Yochadihe and Cachaldihe because they were the ones you had been consulting with on this, and it was an opportunity for them to provide more input?
Yeah.
Now, if you could move down to page or paragraph 86, you describe work packages, addendums that were created and provided to the tribes, Yochadihe and Cachaldike in this case. How many pages would you estimate were sent altogether?
I have no idea. I'd have to look back. I don't know, Danielle, if you have a sense. I mean, I have no idea.
They're not really very big. They just show some maps of where activities occurred and what was monitored and the results of monitoring. So they're pretty small, probably under 20 pages each.
So would you say less than 100 pages total?
Probably close to that, yeah. Yes.
And now if we can move down to paragraph 87. I have a few questions about these isolated archaeological artifacts. Do you know off the top of your head which county these artifacts were found in?
Lusa.
Thank you. And so because of that, only Yochadihe and Cachaldihe were tribal monitors in that case, since it was in Colusa County.
The authority has been open to having other tribal monitors. Paskenta has expressed an interest in monitoring in Glenn County and North.
And then if you could move down to paragraph 88. On the following page, sorry. Lines 1 through 3. So tribal monitors have participated in all geotechnical investigations to date. But so why is it that Paskenta, if they've expressed interest, have not had a tribal monitor present?
We haven't done drilling or geotechnical activities in Glenn County, I don't believe. We are actually, can't remember if it's in the testimony or not, but we are actually working on a contract with Paskenta to provide reimbursement for tribal monitors once we have work in Glenn County.
And then if we could move to paragraph 91, please. Just that first line, you state that notification letters were sent for test pits. These were not cited as an exhibit explicitly. Is there a place where those notification letters are available?
I would have to look through specifically. I don't know offhand, but that is something we could look for and circle back with.
Do you believe they are an exhibit somewhere, or is that something that needs to be added?
Sorry. Let me just go through these. I think these are not, my inclination is that all 7 of them are probably not exhibits. Because Sites 95 focuses on the overall project generally. And includes a little bit of geotech, but not comprehensive on geotech. Sites 99, 100 and 101 may have the letters for Cachal Dehi, Yocho Dehi, and Paskenta respectively, but I'd have to look through all of the attachments to verify that. So I don't think all 7 letters are currently exhibits. There may be a smaller subset that are exhibits.
Would you be able to speak of the contents of those notification letters?
Probably generally, yes.
Did this notice request a response from tribes?
It most definitely would have requested a response from tribes, and likely within 30 days of receipt to comply with AB 52 statutes.
So would failure to respond to the notice then exclude tribes from receiving updates?
No, but I think we see that with Cachal Dehi, who didn't respond to the 2022 or who responded that they did not want to be gosh, that's not the right way. No, failure to respond within 30 days would have resulted in them not being formally consulted with under AB 52. However, the authority, I think through other examples, such as Cachal Dehi's letter on the 2022 to 2024 geotech, when they later expressed interest, we did include them in review of reports and tribal monitoring for geotech activities.
Thank you. So if we could go down to paragraph 95. And so here on lines 18 through 19, you state that Cachal Dehi requested confidentiality of this letter specifically.
Was our understanding, yes.
And same with the September 29th, 2023 and October 12th, 2023 letter and list of citations.
I should clarify my response. Cachal Dehi, I do not believe requested confidentiality of that May 3rd letter specifically. I believe they requested, I believe they identified that anything marked confidential was to be kept confidential. I would need to double check on that, but I believe it was kind of a little bit broader statement than specific letters.
And in terms of that confidentiality, who would be the parties a part of that confidentiality agreement between the tribe?
I don't think that this is necessarily a confidentiality agreement per se, but AB 52 statutes call for confidentiality in some of the information shared, and we wanted to honor that. So we, the authority, wanted to be very careful in what we made public as part of our administrative record for the final EIR and the AB 52 consultation process. But there is not a confidentiality agreement per se. It just follows the general confidentiality, I'll say, request in AB 52 or guidance in AB 52.
Let me reword that question. Who at the authority has access to that confidential letter or other materials?
I have access, and our group that works on tribal issues and outreach and tribal cultural resources would have access, although if I remember, Danielle, I think we kept that to a smaller group and not our cultural resources group were not given access. Our executive director would have access to that. And then our legal counsel that was helping us with the EIR would have access to that letter.
I know the easiest spot was,
So Ms. Reese would also have access to it, that letter.
Yes, she was assisting me on these efforts. So yes.
And then my final question for you, if you could go down to paragraph 99, please. And here you describe a letter or a meeting, sorry, with Assembly member Aguiar Curry. Could you give some context about what this meeting was about?
Sorry, I was on mute. I believe you're referring to paragraph 100 here.
I'm sorry, yes.
Sorry, can you restate your question?
I'm just asking what this meeting was about, if you could give some context.
Yeah. Yes, the authority was invited to a meeting by the Assembly member's office to have dialogue on the sites project and our tribal consultation efforts. And to, yeah, I'll leave it there.
And you were in these meetings?
I did attend this meeting, yes.
Okay, thank you. I would now like to switch over to Ms. Reese. Am I saying that correctly?
Rissy,
Rissy. Apologies.
thank you. No worries.
And Officer Kinsey, I may have another hour left
Thank you.
just to address.
Letting me know.
Okay, so I'm asking the same question I asked Ms. Forsyth. Have you ever had to take cultural sensitivity training?
I have prepared and given cultural resources awareness training myself as related to historic properties or Section 106 type purposes. I have not taken a specific cultural resources sensitivity training myself.
Have you been formally trained on how to engage with tribal governments or individuals?
I have not taken any specific courses or training related to that subject. I have taken trainings on NAGPRA and Section 106 related pieces.
So you would say most of your training experience has been on policies rather than how to engage?
Cultural resources management efforts and archaeological efforts, yes.
And so are you familiar with the OPR technical advisory guidance on AB 52?
I am familiar.
And so I'm going to read a section of it briefly. Evidence that may support finding of a tribal cultural resource could include elder testimony, oral history, tribal government archival information, testimony of qualified archaeologists certified by a relevant tribe. And I'll stop there. Were you certified by any of the tribes contacted for consultation on this project?
No, I was not.
And then, are you aware of the conflicts and negative experience and overall poor relationships between Native American tribes and archaeologists?
I'm aware.
For the analysis of tribal cultural resources, have you been in the field at all on this process?
Just to be clear, I was not an author and did not complete the analysis. I reviewed some of the chapters for the EIR, EAS.
Thank you. And so now I'd like to turn to your testimony, Cites 91. And so in paragraph 1, and as it extends to page 2, but you describe that you were involved in cultural resources management projects in Nevada. What sort of work were you involved in those projects?
I was a field director and principal investigator on numerous cultural resources management projects, mostly archaeological inventories. So doing field work, doing some excavation doing some artifact analysis and reporting and coordinating with clients and agencies and tribal monitors in some cases.
And did you work closely with tribes?
Not very closely.
And so if you could scroll down to paragraph 2, you describe a little bit more of your background. Are you familiar with the tribal landscape of California?
I'm familiar with the tribal landscape in general of California.
Are you familiar with California tribes' practices, traditions, and history?
I'm not super familiar with every tribe. There are a lot of tribes in California. But I have been working on cultural resources and management projects here in California for the last 14 years.
And is that specific, you're working out of the Sacramento area office? Has your work been focused around Sacramento?
Not very focused around Sacramento, Central Valley and foothill areas of California. I also do work in Oregon, and I work on at least one project in Washington.
And have you worked with tribes since joining the HDR?
Yes, I've worked with tribes a fair amount since joining HDR, primarily related to Federal Energy Regulatory Commission projects, hydroelectric projects.
And prior to this project, have you worked with any of the tribes involved on the consulting?
I've worked a bit with the United Auburn Indian community, but most of the other tribes only very peripherally, as working on projects in Nevada County, Sierra County.
Sorry, Nevada County, and what was the other one? Red? I just didn't hear you.
Nevada County, Sierra.
Era? I'm sorry. Not
I'm sorry, like Placer County area. Let me restate that.
So have you worked with Shingle Springs Band of Miwok Indians?
They have consulted on some of the hydroelectric projects that I've worked on, but not intensely personally.
Thank you. So 7 tribes have been contacted sorry, 7 tribes were contacted for consultation, but only a few were involved in the consultation. In your professional opinion, are there cultural resources that have possibly not been identified in the project area or area of impact?
Objection calls for speculation.
Can you rephrase the question, Ms. Willie?
Sure.
I think I can answer that question because I think we do pretty clearly state that not the entirety of the project footprint has been surveyed for archaeological and built environment resources. So certainly there are, I'm sure, additional resources in the area.
Thank you. I appreciate that. And now if we could move to paragraph 7 of her testimony, please. You go down to page 4, please. Thank you. So here, let's see, starting with on line 6, you give some examples of places that have been identified on other projects you are familiar with. Are these examples of projects that you just know of versus, or are they projects that you have personally worked on?
Some are projects that I have personally worked on, and then some are projects that I'm familiar with.
And so several, or I would say most of these examples you provide are specific places, but are you, let me see. Do you have experience or knowledge about tribal cultural resource identifications related to more regular traditional life practices versus defined cultural landscape or specific sites?
Objection vague, lacks foundation. Traditional cultural life practices has not been defined, or there's no indication she has an understanding of it.
Maybe Ms. Willie, if you can describe what you mean by that phrase. We'll start there. And
Sure.
in your question.
So traditional life practices like gathering traditional plants or grinding rocks, which are regularly used, but not things that are stagnant or attached to the land. I don't know.
I have worked on projects where, traditional cultural properties have been identified that are similar to what you are referring to. I'm not an ethnographer or a person trained in working with tribes to identify those kinds of properties, but I'm familiar with those kinds of studies, and I've certainly read them and reviewed them and that sort of thing.
And just for clarity's sake, what do you mean by properties?
I'm very used to, the definitions of tribal cultural resources or traditional cultural properties for Section 106 related efforts. And so for me, properties are usually a place, object, district, cultural landscape for tribal cultural resources. So that's kind of what I'm referring to.
Okay, not just real property, correct?
Yes, correct, yeah.
And so in your experience, do you have an estimate of how many tribes are you typically consulted on a project?
I think it varies quite a bit depending on the scale of your project. Do you cross multiple counties? Probably for larger projects to anywhere from, like 5 to 15. It seems to vary quite a bit.
Thank you. Now if we could go to page 4. And then the footnote 1. Sorry, footnote 1 on page 4. Thank you. So here, it states consultation between government agencies, Native American tribes shall be conducted in a way that's mutually respectful of each party's sovereignty. How would you define or explain mutually respectful?
I think that individual tribes have individual preferences for how they would like to conduct consultation, and that should be considered as part of the consultation effort. And likewise, I think government agencies also have designated parties and things that are leading the consultation for those parties, and that should be considered as well on both sides.
Thank you. And if you could scroll down to, yes, thank you. So here, line 6, starting, you state that the consulting tribes not provide, or let me see if that's right. They not provide the authority of an explanation for lack of specificity. And then line 5, that they provide very little detail regarding specific nature, location, and potential project impacts to tribal cultural resources. What is the level of detail necessary to disclose for identifying tribal cultural resources?
I think tribal cultural resources are tangible resources as they're defined in the regulatory information. And so I think having a location is important as much as can be shared. And then also understanding, to some level, what makes the resource important, what components are important to help maintain the significance of that tribal culture resource.
And for the location, what level of specificity is necessary for that? Do you need a pinpoint dropped location, or is a general area okay?
I think a general area.
And just confirming that was not provided by the consulting tribes.
Not to my knowledge.
were those details requested further at a later date?
I believe those kinds of details were requested throughout the consultation effort to help identify tribal culture resources and additional, information and details to help identify the project impacts and identify appropriate mitigation measures.
And bring it back to the May 3rd confidential letter and other confidential documents. I know you are aware of the contents of those documents. Did any of those documents include the details that are needed for identifying tribal cultural resources?
I'm not sure how much of that information that I can share, so I just hesitate providing a response. I guess I can say I did not see a map in there. And then also I want to be clear that I don't think the authority's assessment or analysis is suggesting that Calusa tribal culture resource does not exist. I think the analysis suggests that tribal culture resources are in the project area and are going to be impacted significantly. There just is not enough information to provide additional details regarding those impacts.
And I just want to add here that this is Ms. Forsythe, that there's a letter from the authority to Calusa, Indian Community Council in Site 095 as attachment GG. And it's on page 503 specifically of that document. Does go into detail about the number of requests and the times that the authority has asked for information from the tribe to help the authority meet the requirements of the Public Resource Code and AB 52 to include this information in the final EIR. And so that's Danielle speaking to it very well. And I think this document in the record helps demonstrate that.
Thank you. And if you could scroll to paragraph 10, please. And so again, here you state that the tribe did not identify specific sites or locations or other information for the Yochadihe tribe specifically. Are you familiar with the living patterns of the tribes in the Central Valley, specifically the Northern Central Valley?
What are you referring to specifically? Can you provide a little more information? What do you mean by living patterns?
Sure. Are you aware that villages of some of the tribes used to change season to season due to weather patterns and suitability of the land?
Yes.
So with that knowledge, wouldn't it be difficult for the tribes to specifically identify those locations?
Objection argumentative.
Overruled.
I think there are identified village sites in the ethnographic literature. And it sounded like in the consultation efforts and the information that was provided that there are village sites and burial sites of concern to the Yochadihi. It sounded as if there are locations, but I am not aware of those locations, or if those locations do not exist, I am not sure.
Thank you. So if you could go to paragraph 11, please. So line 8, sentence, the authority has requested additional information regarding the traditional cultural landscape to better understand and assess potential impacts to the landscape. Are you aware of any other locations in Northern California that have been identified as a tribal cultural landscape?
Yes, on other projects, yes.
And did that specific, the one you're thinking of, have similar features to the project area?
The one I'm thinking of is on a river, so it's a little bit different, and but otherwise it likely could include the same kinds of features.
And in the authority seeking to understand how the cultural landscape is significant, are those other tribal cultural landscapes being looked at?
The one that I'm thinking of is being looked at according to the California Register criteria.
I'm sorry, can I clarify?
Yeah, sure, thank you.
Is it being looked at by the authority to understand what a tribal cultural landscape is and entails?
Is it being looked at by the authority, another traditional cultural property?
Landscape.
Or, I'm sorry, a tribal cultural resource on a different project? No, not that I know of.
I can also speak to this a little bit because I think maybe there was a conversation that Danielle was not involved in. I did lead a small group effort to look carefully at the Delta Conveyance Project's determination of a tribal cultural landscape, and if there was something similar that we should do for sites in consideration of what they had done. We looked at that document carefully and felt that we still didn't have the information that's called for in AB 52 to make that determination. So AB 52 defines tribal cultural resources in specific ways, very clearly in the statute, and also defines a tribal cultural landscape in the statute. And we felt that we didn't have the evidence and the information necessary to meet those statutory requirements in AB 52. It's reflected in Sites 95, attachment GG. We did ask the tribe for such information on a few different occasions. And there was general information provided about the connection between Native people and natural landscapes. However, we weren't able to get enough information to evaluate and include this consistent with the statutory requirements that we felt were called for in AB 52.
Okay, thank you. Um, And then if you could scroll down, please, to the bottom of this paragraph, I think. Line 17, beginning with the catch-aldehyde has not proposed specific modifications to alternatives or new alternatives. Any specific comments on the project's analysis of impact to tribal cultural resources, or any specific comments on proposed mitigation measures to address impacts to tribal cultural resources? Is it the responsibility of the tribe to propose these modifications or new alternatives?
Objection vague.
Which part?
Well, is she talking about some sort of legal responsibility or just responsibility in general, or?
Can you be more clear on that, Ms. Willie?
Sure. I would say the responsibility within the process, like see if I can reword this. Like, is it a requirement for the tribes to propose these modifications to new alternatives or new modifications to alternatives or new alternatives?
The AB 52 requirements do not require the tribes to provide that information. They ask that the agency consulting bring these topics up and coordinate with the tribes on any mitigation measures or alternatives that they suggest.
And in your experience, do tribes often have the expertise to formulate these specific modifications or new alternatives?
In my experience, usually the information regarding alternatives is more related to ways to avoid particular areas or resources. And that's been the most common way that I've seen alternatives discussed by tribes.
Thank you. If we could go to paragraph 12 and roll over into the next page, possible. So just to summarize what the next prior page said, that the final EIS made this conclusion here, the top of the page, that the project will have significant impacts on tribal cultural resources, and that includes destroying or eliminating access to any resource potentially present in the inundation area, such as but not limited to gathering of plant resources, and inundate Native American ancestral sites, disturb known or currently unknown burial sites, disturb or destroy both surface and buried tribal cultural resources, and alteration of the landscape which could disrupt cultural and spiritual practices. Are you familiar with this conclusion?
Yes.
So this conclusion states that there will not be any way to avoid harming these irreplaceable historic and cultural resources, correct?
I'm sorry, can you repeat that question?
Sure. So the statement, from the statement, we can conclude that there will not be any way to avoid harming these irreplaceable historic and cultural resources. Is that correct?
I think if you look at the project as an overall, yes, there is going to be harm that cannot be eliminated. I think when we start getting down to more specific information, the intent is to always avoid first if possible. So I think there is some opportunity to avoid some specific resources, but yes, not all resources will be avoided.
In your experience, how often are tribal cultural resources damaged or destroyed in order to go forward with the project, regardless of mitigation measures?
I would say on large projects like this, it's common, very common.
And is that projects that you've worked on personally, or all projects that you're aware of or have studied?
Just some of the larger projects that I've worked on personally.
And then if you could scroll down to paragraph 13. That's fine. So this is a list of the mitigation measures. I won't go through them in detail, but with these mitigations, would you be able to give an example of mitigation that would happen to, for example, a significantly sized village site that was uncovered in an area that would be inundated by the project?
So a resource, let me just ask you for clarification. So, and like a village site that would cannot be avoided and would be significantly impacted. Is that the kind of resource?
Right.
And how it would be treated?
Mhm.
So I think the way that we've outlined the mitigation measures included in the final EIR, EIS does provide for a process for addressing such impacts. And there are, professional standards for addressing impacts to archaeological resources through data recovery or excavation. But the flexibility of the mitigation measures require consultation with tribes, agencies, and other interested parties. And through that consultation, appropriate mitigation for a specific resource would be identified. That's the good thing about the flexibility of these measures, because each resource has specific needs, and consulting parties often want different things for different kinds of resources. So it allows for flexibility on how to do that.
Okay, thank you. Sorry, did you provide a sort of conclusion or end result for that example?
I don't know that I provided an end result. I think we were just discussing how that kind of resource might be mitigated. And I think I answered that. Am I missing a question?
Oh, no, I was just making
Oh,
sure.
okay. Okay, thanks.
Do you have potentially a end result for this type of situation?
Just
I-
been
go ahead.
vague. Can we re-ask the question?
Yes, please. Ms. Willie, will you repeat the question in full?
Sure. So for the example of a significantly sized village that would be impacted by the projects, what would be the potentially end result given the mitigation measures?
I think the end result would just be reporting on how the mitigation went in the resolution and what was done to mitigate the resource.
And sorry, what would the resolution be? I guess maybe that's what I'm asking for.
That the resolution on how to mitigate a resource has to be determined in consultation with the various parties. There are too many options, and it's just, it depends on the resource and what the consulting parties feel is the best way to mitigate that resource.
Thank you. And then if we could move down to the mitigation measures on page 8. Thank you. Would you say that all tribal cultural resources are archaeological resources?
No, not at all.
Um, Sorry, 1 second, just finding spot. Line 11, you discuss a cultural resources sensitivity training. Have those training materials been developed?
No, not for the project as a whole. We have been doing sensitivity training for our geotech efforts. And cultural specialists have led a cultural and archaeological component of those. And the tribal monitors that are present have been also providing some input on that training. And did I clarify that was for the geotech efforts that the monitoring is going on for?
Yes.
Or getting this? Okay, great.
And then you also state that tribes will be invited to participate and lead part of the training. And I know you just mentioned the tribal monitors have been participating in that. Is that correct? And that would be for Ketchel-Dihe and Yocha-Dihe.
Yes, for the geotech related trainings, yes.
For those trainings, have those tribes been invited to lead part of the trainings?
We invite the tribal representative to speak to the group. It's usually all the geotech workers, and we invite the tribal representative to provide any input they would like to present that the construction team needs to have.
And are these tribal representatives tribal members?
I believe they have all been tribal members, but I do know that they aren't always necessarily tribal members for the tribes that they are monitoring for.
To be clear, though, that these tribal monitors are provided to the authority under a reimbursable contract from Yocha-Dihe and Ketchel-Dihe. We do not have any requirements in our contract that they be tribal members or members of certain tribes. We allow the two tribes to pick the monitors as they feel appropriate.
Thank you. Um, Then if we could, sorry, let me find. Scroll, if you could scroll down to line 16. Oh no, I'm sorry. Yeah, so for line 16 to 19, you state that there will be standards for when tribal monitoring activities will be invited at the end of that sentence. So are there points when tribal monitors would not be invited?
So I think it's TCR 1.2 provides that tribal monitors will be invited to observe all ground disturbing activities. But there are likely other times when the tribes would like to have tribal monitors participate during archaeological surveys or excavation. And the idea is that the plans would be developed in consultation with the tribes and identify those times when tribal monitors will be invited, other than during ground disturbing activities.
And just to confirm, the tribes that will potentially have tribal monitors are Cachel-Dihe, Yocha-Dihe, and Paskenta, is that correct?
At this time, but I think the authority would welcome other groups if they wanted to monitor as well.
And then if we could go to page 9, paragraph 17. And here you mention 2 known cemeteries. Are these tribal cemeteries?
It is likely that there are tribal individuals potentially at both cemeteries, and more than likely at least one of them.
And would those individuals be treated under the plan that was provided by Yocha-Dihe?
The plan that was provided by Yocha-Dihe, I think, is a little more focused on inadvertent discoveries of remains, probably with some, standards for treatment of materials that might be uncovered. And we would incorporate the appropriate pieces into our into the cemetery relocation plan, which certainly would be developed in consultation with the tribes and other parties.
So in these instances, the tribal people that were buried there will be treated separately from the rest of those located in the cemetery?
I believe each interred individual will be kind of considered as an individual. I think there are certain requirements when you have a dedicated cemetery. I'm not a cemetery relocation specialist, so I don't want to misspeak, but I think we would need to, identify the appropriate descendant. And if that is, the tribe as a whole, then that is what that is. But I wouldn't want to speak to what the laws require for relocating a dedicated cemetery.
I will just really quickly say that it is the authority's intent and approach as we develop this cemetery relocation plan to identify descendants, could be individuals, could be the tribe as a whole, and do our best to honor the requests of the descendants. So we are not just intending to move the cemetery as is to another location. We are intending to work with all of the descendants that we can find and honor their specific requests to the best of our ability. There will be individuals that we can't find descendants for. And we need to figure out exactly what we're going to do with those. And that's part of the cemetery relocation plan. Those individuals may be moved to a local cemetery, but we are not intending to move the cemetery as though it is a whole and like a whole item and just move it somewhere else. There's a lot of work that we anticipate to reach out to descendants and do our best to honor their requests for both cemeteries. I know I said that singular, but that's for both.
Mm-hmm. And do you have an estimate of how many people are in each cemetery?
Ooh. I'd hate to provide, I feel like based on the research, the previous records, I want to say maybe 30 at one and 20 at another, but that's just off the cuff. So
Okay.
I'm not totally sure.
Yeah, general estimates is fine.
Yeah.
And how long, I know you're going person by person, how long does it take to identify one singular person and their descendants?
Ooh.
Gonna take time.
Yeah.
We are starting, I'll just answer real quick. We are starting on drafting the cemetery relocation plan now, even though both cemeteries will not be affected until the reservoir is inundated. Because I anticipate that this will take quite a bit of time. And so I would like to start now. There's just a lot to do in field work and logistics, and these are very emotional decisions and very passionate decisions, as they should be for someone's ancestors. And it will take time for families to make those decisions. So this is something that we have prioritized to get moving early in the project and are actually just starting to very early draft this plan and think about how to approach this.
Okay, thank you. So you may not have an answer, but do you have a time frame of when that's all expected to be completed?
I don't feel like we have a specific time frame. I mean, if all is successful through the water right proceeding and the number of other permits we need to obtain and financing, we would fill, our target right now is to fill the reservoir, start filling the reservoir around 2033. which is 9 years from now. So I would say it will absolutely have to be done, by the time we start filling the reservoir. But I don't have a specific time frame for how much time this is going to take.
And if it's not completed by the 2023 fill goal line, will that be extended?
But imagine so. We want to make sure that we have final disposition of these individuals and honor them as individuals before we fill the reservoir.
Um, and now if you could scroll, let me find this. Yeah, if you could scroll to the bottom of paragraph 17, I think. You discuss burial treatment plans. And you use this term grave goods frequently. Could you describe what grave goods are?
Items usually identified in association with burials or where a potential burial is suspected would be considered grave goods, and they have a special status because they are potentially associated with these burials.
And have these burial treatment plans started being prepared yet?
No, we have not started working on the burial treatment plan. We do have similar plans that we are currently using for the geotech efforts, but this would be a separate plan developed for the larger project.
And then if you could go to paragraph 19, please. And so in this section, line 3, it starts, these measures involve. And the first bullet or first number 1, avoidance and preservation in place of a tribal cultural resource. Can you confirm that says and, not or, in between avoidance and preservation?
Yes, it says and in my testimony.
And so according to the discussion we were having before about the cemetery, the impacts to those are not being avoided. Is that correct?
Correct. They're in the inundation area for the reservoir.
And then number 3 states creating permanent conservation easements or other interests in real property that are protective of a tribal cultural resource. I have a question around this. How would mitigation be implemented for tribal cultural resources that are going to be inundated under the 1.5 million acre feet of water?
We have these mitigation measures in place. And our mitigation measures will allow for us to continue refining the protocols and procedures for individual tribal cultural resources. So again, it allows for that flexibility to work with those individual tribes on their tribal cultural resources that they have value in, and to identify ways to mitigate those impacts to their resources.
And so these conservation easements referenced, they would be outside the project area, is that correct?
I don't know if it's been determined, where they might be at this time.
I can give an example of something like this. So we may have a resource potentially in a roadway alignment. And, we could, in that situation, use number 1 to avoid that resource and move the road away from that resource, realign the road in that situation. And if it's something that the authority owns fee title of that area, as we've moved the road, I think the authority would be open in creating a permanent conservation easement over that site where we moved the road away from, to preserve that into perpetuity.
Thank you.
It's difficult to move the reservoir, but there are other project features that we have some opportunity to move around.
Thank you for answering. And then if we could go to paragraph 20, the bottom of page 10.
Ms. Willie, I'd like to check in on a time check. We've been going about an hour and a half. We
Okay.
could go a little longer for a break, but I also wanted to check in with you. I think originally you suggested an hour and a half after lunch, and I think if we're like you have more.
Yeah, maybe like half an hour more.
Okay. I encourage you to move forward. I mean, this is important, and I want you to ask your questions, but see if we can move it along.
Mhm.
Thank you.
1 second. Okay, the line 20 through 22 states that the authority incorporated example measures from the Public Resources Code. Were those mitigation measures just copied over straight from the Public Resources Code?
For the most part, I don't know about word for word, but for the most part, yes.
So were there efforts made to create separate mitigation measures aside from those examples?
We do have, the other mitigation measures that are included for tribal cultural resources. One is requiring the monitoring of all ground disturbance, and the other one incorporated the Yochadihi Wintu Nation's preferred treatment for human remains.
Thank you. And then if we could go to paragraph 21 on the following page. Okay, so regarding the programmatic agreement, if you could scroll down to line 12. There's a list of agencies that will be involved in this, and it states other signatories and concurring parties. Would tribes be included in those other signatories and concurring parties?
I believe the programmatic agreement, which Reclamation is developing, they've provided a draft. They're working on a second draft. And in that second draft, as I understand, there are several tribes that are listed as signatories and other tribes listed as concurring parties.
Thank you.
Danielle, I just want to clarify, that's what we've heard verbally from Reclamation, but we have not seen the second draft of the programmatic agreement, correct? That was my understanding.
Yep, that's correct. We have not seen it yet. That's just what we have heard.
Okay, let me see, trying to pare down here. So are the public resource, going back a little bit, code mitigation measures meant to be sort of a standard among mitigation measures?
As identified in the regulatory language where those example mitigation measures are included, it states that if there are tribal cultural resources that are going to be impacted and tribes do not offer up their own suggested mitigation measures, then the example mitigation measures can be used.
And I believe, correct me if I'm wrong, but that states if at the end of consultation or at the conclusion of consultation that there's no agreed mitigation measures. Is that correct?
Correct. I believe you're correct. Yeah.
So would you say AB 52 consultation is completed at this time?
Yes.
Okay, thank you. If we could go to page 12, paragraph 23. You state that there are no tribal trust lands or lands held in fee by Native American tribes within the project footprint. Could you again, sorry, describe the what is considered to be the footprint?
The project reservoir and the associated features, the existing conduits and proposed pipelines and regulating reservoirs.
So are the related rivers and waterways considered part of the footprint?
Not part of the footprint for the project facilities.
So would you say there's two footprints, one for the project facilities and then one for the project overall?
I don't know if I would describe it quite that way. I think there's the proposed project and then there's probably the area in which the proposed project could have impacts, which I think is including the waterways and things you're suggesting.
So then they would not be a part of the footprint.
Correct.
That's right. Okay. Do you know if water resources are included or protected under Indian trust assets?
I hesitate to provide a lot of answers to this section, as this section was in the final EIR-EIS, was really developed by Reclamation. But I mean, tribal trust assets are Indian trust assets, and they're legally defined. with legal interest in property. So I don't believe that includes like the Sacramento River, or the American River, or the Feather River.
Would it include groundwater that is beneath the real property and used by tribes?
I think I would have to understand a little bit more about groundwater and where it is that you're referring to.
Sure, I'll provide a sample or example. If Catchell Dehay uses groundwater as a resource, and that is a federally listed reservation, would that groundwater be protected under as an Indian trust asset?
I actually do not know the answer to that.
Okay, thank you. Okay, if we could go to paragraph 25 on page 13.
Ms. Willie, would this be a good time to take a break?
Um,
Or would you like to finish this section on tribal lands? Does that make the most sense?
we can take a break right now.
Okay, I would like to go ahead and let's do a 20-minute break. And I will see all of you back at 3:03. Thank you.
While we're waiting, if I could ask clarification on Ms. Rissi, I think that's how you said it. You said you have taken trainings on NAGPRAC or something like that?
NAGPRA,
Yeah, how do you spell that?
let me see. I just want to make sure I get it right. It's an acronym. It's
Yeah.
NAGPRA.
NAGPRA. Is it all one?
Mhm.
All of, okay. Thank you. And then section 106 related, is that right?
No, NAGPRA is its own law. Section 106 is Section 106 for the National Historic Preservation Act.
Well, I think the sentence was, I have taken trainings on NAGPRA and section 106 related.
Yes.
Yeah, okay. Just want to make sure that was
Yeah.
right.
Thanks.
Perfect. Thank you. With
All
that,
right.
I'm ready.
Great, thank you. With that, we will continue with cross-examination of panel 9, and I will turn things back to you, Ms. Willie.
Yes, 6 lines of questioning left, so we'll try and power through. If we could bring it up, the testimony again, I think 71. And turn to page 13, paragraph 25.
Is this question for Ms. Rizza?
Yes.
Did you mean then cites 91?
Oh, yes,
I
sorry.
believe it cites 91.
Thank you. And so I want to bring attention to the statement made by Catchell D. Hay. It's a pretty powerful statement. I won't read it out loud. And following this statement, lines 22 through 24, you state the landscape will not look the same, feel the same, and cannot be experienced in the same way by Native American communities who have lived with and in the landscape where the project is located since time immemorial. Considering this above statement by the Catchell D. Community Council, does your statement lend itself to a situation whereby the tribes would believe that the authority has the tribe's best interest in mind?
Objection calls for speculation.
That seems fair. Ms. Willie, I'm not sure what you're getting at with this question. Can you try that one again?
Is it reasonable for a tribe to read your statement and believe that the authority does not have their best interest in mind?
Objection calls for speculation.
Okay,
Vague.
I'll move on.
Sustained.
In the instance that mitigation measures do not actually lessen severe cultural trauma, which you described yourself, will that be caused by the project? Are they still considered valid mitigation measures?
Uh,
I'm
I
gonna
think-
object as, sorry, Daniel,
Go ahead.
as misstates testimony and vague.
I'll get that one.
Well, maybe try the question again. I think it was all right, but let's try it again.
If the mitigation measures do not actually lessen the impact of tribal cultural resources for tribes that will be caused by the project, are they still valid mitigation measures?
Objection vague. I'm sure valid refers to.
Overruled, I think the witness you can caveat as appropriate, but answers as you to the extent you can.
Okay. I think that the regulatory requirements and language around mitigation for tribal cultural resources does not specify that if the impacts are as detrimental as what you were saying, that they are not valid. So I would say the mitigation measures are still valid, even understanding the level of impact. Did I get that question right?
Yeah, thank you.
Okay,
Just
thank you.
poor wording on my part, sorry. And then if we could go to page 14, paragraph 26, potential impacts to tribal interests. You refer to tribal interests several times. Could you possibly define what you mean by tribal interests?
That's a good question because I had a really hard time discerning what I should identify as tribal interests because the tribes are the owners of their own interests. And so my testimony here, because I wanted to make sure that what I was speaking to were interests as expressed by tribes and entities associated with tribes, some of the NGOs, that I utilized the comments received from tribes and tribally associated entities on the revised draft EIR and supplemental draft EIS. And so the tribal interests I have identified here are really hopefully just the interests as expressed by the tribes in those comments.
And potentially for more clarity, would you classify the interests as simply areas of concern for tribes? Or are they more than that?
I don't know if they're, I mean, I think the tribes, based on the comments received, felt very strongly about these. So whether or not you describe them as interests or concerns, I'm not sure which is more valid.
Thank you. And so further on in this, or throughout the remainder, you make statements that the authority acknowledges or understands certain things. What does it mean for the authority to acknowledge or understand these issues?
I think what it means is that the authority did review all of these comments and did consider them thoroughly when addressing them and when completing the final EIR EIS.
Thank you. And would you say the authority is committed to protecting tribal culturally important resources?
Yes, I would say they are committed.
And then if we could go to page 17, please. Are you familiar with the racial equity efforts that have been made within the State Water Resources Control Board?
I am very generally familiar.
How about Ms. Forsyth, the same question?
I would say generally familiar.
Okay, if we could bring up one of my documents, Sites Cross number 3. Are you familiar with this document? Either of you?
I'm generally familiar with it. I have seen it, but I don't know word for word what it says, of course.
Have you read it?
Probably not word for word, but I have looked it over, yes.
And Miss Forsyth, same question.
I think that's the same. I definitely recall skimming it. I'm not sure that I've really read it word for word, but yes.
Thank you. And if we could go to SCS Cross 2. This is the Racial Equity Action Plan by the State Water Board. Are either of you familiar with this document?
I have skimmed through it and I am aware of it. But again, I don't know it word for word.
And if we could go to page 14, row 2. Sorry, page 14. Thank you. So this first box, consider impacts to BIPOC communities, tribal beneficial uses, and cultural resources and related ecosystems when developing, implementing, and enforcing in-stream flow requirements consistent with all applicable laws and requirements, including those related to water rights. This is one of the actions that the State Water Board is in progress of working through. Would you agree that this proceeding would fall into this action?
I'm not sure what the BIPOC acronym is.
Sure.
And then I'm not sure what you mean by fall into this action.
Sure. BIPOC stands for Black, Indigenous, People of Color. It's an acronym used frequently in racial equity work, just for reference. And let's see if I can reword this. Since this is a water rights proceeding, would you agree that it would be a proceeding that would fall under this action, since it references let me try and reword this. I guess, would you agree? Can you see that this says related to water rights?
Yes, I can see that. Yeah.
And is this a water rights proceeding?
Yes, it is.
Okay, thank you.
So, I mean, I think you asked if this pertains to water right proceedings, and I guess I look at this and it is for enforcing in-stream flow requirements consistent with all applicable laws and requirements, including those related to water rights. And then the last column, I don't know what the 3 middle columns are, but the last column talks about web pages for ongoing in-stream flow development activities. So this seems, I think it's up to the state board to determine if this is applicable or not, but the way I read this on the surface, it says to me, it's in-stream flow requirements. Which a water right proceeding, I guess, in and of itself is not an in-stream flow requirement. There could be components such as enforcing the Bay Delta Water Quality Control Plan that are.
I understand, thank you. That last column is just where they are in the process of considering the impacts to these types of communities. So that being said, neither of these documents were considered or integrated into the planning for the project so far. Is that correct?
Objection. Oh, I would draw that.
I will say from my perspective, I have reviewed the board's policy, especially as I can't remember if that came out before the authority board developed its strategic plan. But I want to say there was work on it around that time frame. So the authority board has a strategic plan that includes diversity and inclusivity. I believe I reviewed the board's policy as we develop that strategic plan and as we think about how we're implementing our work. I am not particularly familiar with this document, so I did not include it. And Ms. Reese, I'll let you should answer if you had included any of these in your work.
No, I have not.
And sorry, I should say, when I say board, I mean the site's project authority board. As our board developed a strategic plan, we had looked at a number of different documents around diversity and inclusivity
And
and
one of,
racial equality
sorry, and one of those was the resolution that was first on the screen.
that I had looked at personally to think about that. Yes.
Okay, thank you. And then if we could go to back to Ms. Reese's testimony. Paragraph 44. You discuss a memorandum of agreement between certain tribes, but I was wondering how you came to the decision to only include those five tribes.
I think this is consistent with Ali's testimony that those are the 5 tribes that the authority identified that are most closely associated with the project footprint and impacts being caused by the project.
And have tribes expressed interest in this agreement?
I think there has been some interest.
Do you know from which tribe specifically?
I think there's been some interest from Yochadihi, some maybe from Paskenta. I don't know, the Quechua-Dihi band of Wintoon Indians was very favorable on it. I don't know if Ali have additional input.
I don't have additional to add to that.
I'm sorry, did you say you don't know if they were favorable or they were not favorable, the Quechua-Dihi?
I don't believe the Quechua-Dihi were very favorable to the memorandum of agreement.
I think I'll add a little bit more into that because I was involved in the consultation efforts in 2023. We did have some interest from Yochdehi and Paskenta on the memorandum of agreement. The discussions with Quechua-Dihi in 2023, when we were having a lot of dialogue I believe we had brought this up sort of in passing, but had not broached the subject in any detail. I believe at one point we had, I was about to say, I believe that we had emailed them like a concept paper, but I'm not confident on that. So I think it's fair to say that we never really got into the details or depth of discussion on a MOA with Kachal-Dehi.
And is that concept paper included as an exhibit or otherwise available?
I would have to look back at sites 95. The attachments. Yes, it is in site 95, attachment X, which is page 423 of that attachment.
And just confirming that's a concept page for the memorandum of agreement between these 5 tribes, correct?
That's correct. And we were willing to enter into the memorandum of agreement with individual tribes or all of the tribes together. How we were very flexible, but it was a concept page, concepts write-up that we did originally for Yochadehi to allow them to consider it a little bit more in depth, and to consider whether they wanted to take it to their tribal council for input.
And is there a date associated with that?
The date on it is October 18th of 2022.
And so since then, there have been no conversations about it moving forward. Is that correct?
We had a couple of conversations with Yochadehi. Sorry, let me just get back up there. We had a couple of conversations with Yochadehi in 2022. Oh, why is this dated 2020? All right, just want to double check. I would need to double check the record just to be careful. We did have a couple of conversations with Yochadehi on the MOA, but as reflected in my testimony, the conversations with Yochadehi dropped off in early 23, and so the discussion of an MOA kind of ended at that, drop off. The conversations with Kachal-Dehi in 2023, we never quite got to a spot where where we felt like this would be it. We never quite got to the spot of discussing the MOA in depth. And then Danielle, I'm trying to recall if we had talked about an MOA with Paskenta. I think
we did a little bit along with a communications plan with Paskenta that could be kind of memorialized in an MOA.
Yeah, that is correct. That's my recollection also. Thank you.
And with that, I think that is my my final question. Will I be called later in this hearing today, or will I be allowed to drop off the Zoom platform?
Oh, Ms. Willie, if you are complete with us for the day, you're welcome to to go on to other things.
Okay.
But
I just
thank you
want
for that.
Give my computer a break.
Yeah, thank you. With that, and thank you to the witnesses, and thank you, Ms. Willie. With that, I will look back to the coordinating NGO parties, if you will. Is there another representative who has questions for this witness?
This is Eric Busher. I do have a few questions, probably less than 20 minutes, half an hour total. And I'm happy to do that now or defer if there are other tribal representatives outside of the NGO parties.
And maybe as a point
I'll be
point
here
of
tomorrow. So
thank you, Mr. Busher. I appreciate that. Dr. Curdy, I wanted to ask for clarification. You're representing, are you part of the it's CCIC, right? Am I getting the acronym right? Is that part of the coordinating NGO parties, or are you a separate? You're in the
CICC. I am here to speak to the interest and concerns of the tribe, and I am employed by the tribe as a critical ethnographer and sociocultural geographer.
But is CICC part of the coordinating NGO group? Have we clarified that issue?
I believe is not CICC a party. I filed for party status, and I thought, Dr. Kinsey, you had stated that at the beginning of the hearing.
You are a party. I mean, CICC is a party, but I
Yeah.
think it's a separate party from the coordinating NGO group. So I think what we're going to do is I'll go through the coordinating NGO group. It's just a matter of timing. It's not a whether.
Yeah. The only concern there is there's a tribal council meeting at 11 a.m. tomorrow that the executives cannot miss. And so that's why I spoke up at this time, hoping that we would be able to speak to the tribe's concerns today.
I see.
Just putting that on the radar.
And I support the tribe going first because I've also set aside time for tomorrow too, and I think it's important.
Is that Ms. Chicazola? I couldn't tell who was speaking.
Yes, it is. I just had 3 follow-up questions, but I'm part of the environmental coordination people along with Eric. So yeah, I support Giorgio going first.
Okay, then let's go ahead and do that. Please, Dr. Curdy, if you're up, if you would like to ask your questions now.
Thank you. My first question is for Ms. Forsyth. Under CEQA and AB 52, who is legally liable for conducting consultation?
AB 52, I believe, specifies that it is the lead agency. And the CEQA statutes specify the lead agency is the agency with the approval authority, with the decision, the first decision to undertake a project.
Can consultants to an agency conduct government-to-government consultation?
I think it depends on how the government in this case is structured and what they would like to do, and how they would like to engage in consultation and present themselves.
If I'm understanding you correctly, you're saying it's a unilateral choice of a state or local agency under CEQA that they can just decide who conducts formal government-to-government consultation with a sovereign, self-determined, self-governing tribe?
I think the agency makes the decision as to how they would want to conduct consultation.
Are you aware that in technical guidance from OPR, it states that it is the agency's responsibility?
It is the agency's responsibility, and they can choose how to carry out that responsibility.
So you're saying that an agency can defer its government responsibility to a non-governmental entity?
Objection, misstates testimony.
I think sustained, but also Dr. Curdy, can you connect this? I realize it's an important issue for the tribes, but will you please connect it to the hearing issues we have before us today?
The hearing issues around water, around cultural resources, around what was accounted for, requires an understanding of why Kachil Dihi, also known as the Calusa tribe, also known as CICC, only provided certain information. there are certain guidance around consultation, good faith, meaningful, and reasonable consultation. And I'm trying to understand what site's position is, because as early as April 2023, the tribe made very clear to the site's project authority that consultation was only considered a government-to-government act and that their consultants could not fulfill consultation obligations and responsibilities. What we've been hearing consistently is consultation, but it's being thrown around. I think there's their consultants, and then there's the agency. So we need to distinguish between what in this field is very often called consultation with a lowercase c and consultation with an uppercase c. Uppercase c is government to government consultation.
So I understand, and I'm not. I just want to look at this from the within the scope of what the State Water Board is considering. I'm asking for your help to connect it to the hearing issues. Right. There may be other, there may be other claims that about things that are going on here, but I'm trying to connect it to the scope of this hearing to make sure we're on track.
Ms. Forsyth, in previous testimonies from self-identified scientists, at least 3 acknowledged that natural resources are cultural resources. Do you agree? Do you acknowledge that for tribal communities, natural resources are cultural resources?
I do.
Ms. Reese, do you acknowledge that?
Yes.
You've also acknowledged, Ms. Reese, and Mr. Ferguson has supported in his response, that you do not have the competency or qualifications to speak to traditional lifeway practices in relation to these natural resources that may be cultural resources. Is that correct?
Is that question for me? Dr.
Yes.
Judy? Yes, that's correct. I'm not an ethnographer or a cultural geographer or a specialist in those things.
Okay. Ms. Forsyth, did the Calusa tribe repeatedly since April of 2023 convey to you that the project personnel you had doing the cultural resource assessments were not competent or qualified to conduct this work on behalf of CICC?
Objection lacks foundation.
Do you have a basis for that, Dr. Curdy?
A multitude of consultation letters, yes.
And can you bring them up? Have you submitted them? Or are they in the record already?
They should be, but they're not. In an email, Ms. Forsyth reached out to the tribe and asked if these letters could be shared. The tribe's response was, please find attached CICC statements to be added to the Site Project Authority's secret administrative record. CICC reserves the right to provide additional statements.
I'm sorry, if you're going to read, can you please read a little slower?
Sorry. Please find attached CICC statement to be added in the Site Project Authority's secret administrative record. So there were some files shared.
I'm going to check this lacks foundation. He's testifying, and we don't see the document on the screen, and I need
to get permission from the tribe before I can share it. I'm just reading correspondences. Let me ask them. The point is that the tribe did give permission to share these letters. The tribe was very clear. Okay, I just got confirmation from the vice chair. So I can share these letters. So let me send them in right now.
And where are you, just so we can get there faster, where are you sending them, Dr. Curdy?
To sites WR application. Is that the appropriate? Yeah.
Yes, sites -WR application.
Yeah, application at water.
Yeah, thank you.
Yeah, okay. It's going to be a large file. Okay, it was just sent.
Great, thank you.
So while we're waiting for that, I have some questions I can ask Ms. Reese.
Good, please.
Yeah. Ms. Reese, does your HDR training, your ethics training, direct you to follow your professional disciplinary ethics as part of project participation, design, implementation?
I am unsure if our ethics training includes that information. Yeah.
Okay. Are you a member of the Society for California Archaeology?
Yes, I am.
Are you familiar with its code of ethical guidelines?
I think I've looked at them at some point, but it's been quite some time, so would not be able to reference them.
Are you familiar with principle number 3, descendant communities?
Very vaguely familiar. It's been a while since I've looked through that.
And for everyone's information, this is available publicly online. It says all SCA members shall commit to meaningful consultation in good faith with descendant communities with the goal of establishing working relationships that can be beneficial to all parties involved. Members shall respect confidentiality of sensitive information and items of cultural patrimony. Where such information or access to items has been provided, members shall obtain permission prior to sharing in any format and credit the source. Can you relate to us how you worked meaningfully and in good faith with descendant communities?
Is this question for me?
Yes, Ms. Reese, sorry.
Okay, on this project?
Yes.
Okay, so that actually was not my role for this project. I provided some oversight and some review of materials, but my role was not to conduct consultation.
So we have no one here that can testify to what good faith commitments were made to the tribes in the field, correct?
When you say in the field, what is it that you are referring to?
I'm referring to telephone calls. I'm referring to visiting tribal communities. I'm referring to developing trust relationships through processes of inclusion and understanding.
I think Allie, as one of the authority agents, attended a great number of those meetings when she came on board with the authority and can probably speak to a fair amount of that.
That is correct.
So Allie, you had testified earlier that you had searched for cultural sensitivity training, correct? And you couldn't really find anything that really provided a helpful pathway to working with tribal communities?
I believe I testified that there's limited formal cultural sensitivity training. What I probably neglected to say is that there are trainings held, I don't know if I'd call them trainings. There are webinars held by a number of organizations. Actually, the California Natural Resource Agency does. There's a tribal group out of Oakland, and I just cannot recall the name of it right now, that does occasionally. And when I see those and have availability, I generally try and call in. So I'm not sure that there's like here's a 2-day training. I haven't found a lot of those. I think a lot of more of it is more grassroots efforts by organizations that are trying to help connect tribes and agencies together in dialogue. And I've tried to attend a number of those just to continue to understand and improve.
As an agent for the Sites Project Authority, you're an agent of the state of California, correct?
Objection calls for a legal conclusion. It's vague.
I think that's fair. Try it a different way, Dr. Curdy.
Yeah. Did you represent yourself to the Calusa tribe, a consultation in person on April 18th, as the appropriate government official to carry out consultation.
Objection,
is-
Ben. Which April 18th are we referring to?
2023.
I would say yes, the authority board has designated me in my role to oversee its tribal consultation efforts.
Okay. Are you aware that there's a California Office of the Tribal Advisor?
I am aware, yes.
Are you aware that they have cultural humility basics for working with California Native Americans training?
I'm not aware. I believe I've looked through their website, but I'm not aware of that.
Okay. Are you familiar with the concept of cultural humility?
Not entirely. The words lead me to think of certain things, but
Okay.
Dr. Curdy, we have the file ready if you would like us to bring that up. The one that
Okay.
you emailed.
Okay.
Should we bring it up?
Sure. Yes, please. If you could go to page 38 of the PDF. It's a May 3rd letter. Great. If you could go to the begin at the last paragraph of that page. So to give context, this followed up April 18th, 2023 in-person consultation meeting. With ongoing government-to-government consultation, CICC expects the very serious concerns, issues, and insights regarding the elision of CICC from project considerations that CICC shared with Ms. Forsyth and Mr. Spesser at the April 18th consultation meeting to be quickly and restoratively addressed. This must be done to begin to identify, outline, develop, and implement productive pathways that will ensure the full rights afforded to CICC are honored and concerns and insights adequately accounted for under all applicable and guiding laws, policies, regulations, executive orders, and secretarial orders, including but not limited to those guiding CEQA and its AB 52 editions, the National Environmental Policy Act, and the NHPA. CIC stresses to the site project authority that the foundational backbone of reasonable and good faith consultation must be reasonable and good faith compliance with all of the rights under all guiding acts, stipulations, directives, orders, and mandates affirmatively afforded to CICC. As shared by CICC during the April 18th consultation meeting and necessary to reiterate with this letter, is highly concerning that there has been a joint effort at coordinating.
Dr. Curdy, are we getting to a question, please?
If we go back to the first paragraph, it states this letter is written on behalf of the Kachildahi Band of Wintoon Indians of the Calusa Indian Community Council. It goes on toward the end. The site's project authority shall not disclose this letter or any associated details or contents herein, in part or in whole, to any third parties, included but not limited to.
Dr. Curdy, we
Yes.
need a question. You may submit this if you would like to as an exhibit on rebuttal, and then I will read it as an exhibit.
Was this letter provided? Was this letter provided to any consultants?
the
Ms. Reese?
authority.
Hmm?
I can speak to this. The authority did provide this letter to a very limited number of its consultants, along with its legal counsel. While respecting the confidentiality request of CICC, the transmittal from myself to those individuals called the letter confidential and asked them to not disclose it or the contents of it to any other individual. The tribe cannot limit the authority from having discussions with its consultants and its legal counsel. And I was advised of that specifically by our legal counsel prior to distributing this letter to to a limited number of our consultant team.
Did the Calusa tribe repeatedly raise concerns around the competency, qualifications, and ethical commitment of your consultants?
The Calusa tribe did, yes.
So when you say Sites Project Authority was not provided enough information, how can you possibly require or request certain information when you've already testified that you've undermined the trust of a tribe and the protocols of tribal information sharing and confidentiality.
Objection argumentative.
That's fair. Dr. Curdy, can you ask a more direct question?
Does consultation require respect for tribal sovereignty as outlined in CEQA and guidance from the state of California?
AB 52 identifies that consultation requires respect for each party.
That's not what I asked.
That was my answer.
That was not an answer.
Dr. Curdy, please.
Mhm.
Let's remain respectful in this proceeding. You may go to your next question.
Am I to understand that sites did not formalize any confidentiality agreement with any tribe, then made executive decisions about who could have confidential information on their behalf, then expected tribes to provide specific sensitive location information?
Objection compound.
It's fair. Dr. Curdy, break it down, please.
Did sites formalize any confidentiality agreement with Calusa?
Objection
No.
has been answered.
Let's go ahead. I'll allow the question. Please, Ms. Forsyth.
Sites did not. I will say that there are confidentiality components identified in AB 52 statute.
As well as guidance from the state, correct?
I'm not familiar with specific guidance from the state. We were really focused on the statutory requirements of AB 52.
Do the statutory requirements of AB 52 exist in a vacuum?
In the
Objection
context-
vague.
That's fair. Dr. Curdy, what do you mean by that?
Does the state of California provide guidance on how to implement AB 52?
It does provide guidance through OPR's tribal or AB 52 guidance components on how to implement AB 52. Being that we were in AB 52 consultation with the tribe, we were looking to follow the statutory requirements of the law.
Do the statutory requirements of the law of CEQA allow Sites Project Authority to not put equal effort into the no project alternative or any other alternative to the preferred alternative?
Objection vague and lacks foundation.
That's fair. I think a more objective question would be helpful here.
Yeah. Do the statutes require the no project alternative to be given the same level of effort and consideration as any other alternative?
The authority prepared a final environmental impact report following CEQA. CEQA actually requires, or not requires, I should say, allows a lead agency to give the most weight to the proposed project over the other alternatives in an EIR, in a CEQA document. However, because the authority was complying with both CEQA and preparing a joint document under NEPA, NEPA requires equal weight to all alternatives. And thus our final EIS went beyond the requirements of CEQA and gave equal weight to all alternatives, including the no project alternative.
How did impacts to cultural resources, Ms. Forsyth, inform the no project alternative?
I'm not sure I understand the question. Can you explain it?
Yeah, is it not correct that the no project alternative is supposed to describe the state of the environment, inclusive of people, of what would occur if the project was not approved?
That is correct, yes.
Okay.
What is reasonably foreseeable to occur if the project is not approved?
Did the Calusa tribe share information with you as documented in a multitude of the correspondences and consultation letters that if this project goes through, their traditional lifeways will be irrevocably impacted?
They did, and I believe we identified significant and unavoidable impacts in our EIR
So I
for
return
tribal cultural resources.
to the previous question. How then did that inform your no project alternative?
Objection vague. I'm not sure what that is referring to.
I'm referring that to exactly what Ms. Forsyth said, is that they recognized in the EIR that there would be irrevocable impacts to the Calusa tribe's human environment, environmental setting, TCRs, and traditional lifeway practices. That's my understanding of what she just testified to.
That is not correct.
Can you tell me what you just testified to?
I believe I just testified to the fact that we found significant and unavoidable impacts to tribal cultural resources in the document.
Does CEQA not state that a significant, with the AB 52 additions, that a significant impact to a tribal cultural resource is a significant impact to the environment?
That is correct.
Okay, so how did that significant impact to the environment inform your no project alternative in the EIR?
Well, the no project alternative includes what exists today and what is reasonably foreseeable for the future.
Mhm.
And that is what was described in the EIR.
There was no
And-
no description of the Calusa tribe's relationships here, historic district, and defined cultural landscape as had begun to be shared with you from April 18th. So the question once again is, with all of the consultation, with the information provided that's in these letters, including how this area has ceremonial connections, including how this area is part of practices of movement, pause, and return, including how these
Dr.
are
Curdy, you are
Yes.
headed straight toward a compound question here, so
Yeah,
try,
yeah.
try less, please.
So with all of the information provided to you, meaningfully and in good faith, reasonably, how was this information used that had been given to you starting in April of 2023? How did this inform your no project alternative analysis?
Well, let me share a little bit here that may help just clarify this. When we began meeting with the Calusa tribe in early 23, we heard a lot of concerns. Concerns about the individuals and using archaeologists for our EIR effort. Concerns that some of the language that we used was racist in the document and was not appropriate. And concerns that the analysis wasn't adequate. And so we took those concerns seriously. I took those concerns seriously because frankly, I want to be better and do better. I did consult with legal to make sure that we felt that we could share this letter and these concerns with a limited team of our consultants and consult with our legal to figure out how best to address these concerns. I was advised that we could share it with a limited team, and so we did. As a limited team, we got together on numerous occasions to look very carefully at the EIR, what we had written in the cultural resources and the tribal cultural resources sections of the EIR. We changed our characterization in response to concerns that I heard from Mr. Curdy, Dr. Curdy, excuse me, that the language was racist.
Excuse me, Ms. Forsyth, I just need to add, you heard from the Calusa tribe that this was racist.
Thank you. From the
Welcome.
Calusa tribe. So in response to that, we looked very carefully at the language. We changed the characterizations. Previously, we had used terms like history and prehistory, and those are, I now understand those are not appropriate terms. Because they marginalize the view of the Native American community, and that prehistory, you know, is still, pre-contact is a better word to use. Their history exists, prehistory. We also looked very carefully at the governor's executive orders, both Governor Brown and Governor Newsom's. Had a lot of discussions as a team about how cultural resource information today is based on a record developed by white individuals, typically, and their perception of tribes, not written by the tribes themselves. And that much of what we would, I'll just say, air quotes, call history as white individuals, is not written down for Native American communities. It's their oral stories. And so we recognize this in the front of the chapter and really combed through the cultural resources chapter, the cultural chapter, our confidential appendix, our public appendix on all of these topics to just really think hard about who we were citing in these documents, how they were cited, and to be much more thoughtful and sensitive to the challenges and concerns that we had heard from the tribe. We did, on a number of occasions throughout 2023, have requests from the tribe. I shouldn't say request. On a number of occasions in 2023, the tribe did identify a tribal cultural resource in the project area. We had that verbally and through a number of letters expressed by the tribe. The authority and myself did express a number of times, both verbally and in writing, that to comply with the AB 52 statutes, for the authority to determine it to be a tribal cultural resource in our environmental document, we needed additional information to comply with the statute. We never disputed, we never denied, we never questioned. We simply asked for additional information to help us comply with the statutory requirements of AB 52.
Ms. Forsyth, there's several questions here. One is, does not OPR guidance provide an outline, and I believe Ms. Willie shared it with you, of what could count as quote unquote evidence for an agency to find a tribal cultural resource eligible for the CRHR?
We were specifically consulting under AB 52, and we're looking specifically at the statute, the AB 52 statutes, which define tribal cultural resources and tribal landscapes in certain ways.
So is my understanding that you neglected to consult the guidance from the Office of Planning and Research on this matter?
I believe the statutory requirements and the legal requirements are the things that we need to follow as an agency.
And can you follow these meaningfully, reasonably, in good faith without involving guidance from the state on how to do that?
Objection calls for a legal conclusion.
Okay, let me reframe it. What is the purpose of CEQA?
Public
Objection.
disclosure.
I'm sorry?
Sorry, Aaron.
I'm sorry, I didn't catch the answer. I'm so sorry.
The purpose of CEQA is public disclosure and understanding of environmental impacts before an agency makes a decision.
Is it true that the phrasing is often to take a quote unquote hard look at impacts to the environment?
I think that's a fair characterization.
Okay. If that's a fair characterization, why is it that we continually hear about these legal matters, consultation as a hollow checkboxing exercise, rather than really making a good faith, reasonable, meaningful effort to understand what the tribe had been telling you?
Dr. Curdy, are you asking a general question or one specific to this proceeding?
To this proceeding.
Okay.
Yeah, to this proceeding.
Because while it is to
The
take a
adject is argumentative.
Will you please rephrase it because I understood it as a general question?
No, it's in this specific project, this proposed sites authority project. We have heard you reference the statutes outside the context of numerous guidance documents from the state. We've heard you continually refer to legal requirements, for example, around consultation, which I'll get to in a second. You stated it was a fair characterization that the purpose of CEQA was to take a hard look at the environment. So the question is, as part of this project and as part of reasonable, meaningful, and good faith consultation, how was it that you accounted for the tribe's concerns when you continually go back to stipulations minus guidance?
Dr. Curdy, I'm going to object to that question. I don't understand what that means. Make it short, please.
Okay. How did you take a good faith, meaningful, and reasonable approach to the ongoing concerns that the Calusa tribe had raised, beginning at least as far back as April 18th, 2023?
Objection asked and answered.
I'll allow it so we can move forward. Please, Ms. Forsyth.
Yeah, I mean, I think Mr. Ferguson is correct. I mean, we took a really hard look at the document, all of its appendices related to tribal cultural resources and cultural resources, to look carefully at the language, to think about how we were characterizing things, to think about our impacts, determinations along with our mitigation measures, to ask ourselves, are we being thoughtful? Are we being sensitive? Have we covered these impacts? Is there adequate mitigation? Is there more that we can do? And we asked ourselves that a number of times in 2023. And I asked that of our team a number of times in 2023, to really explore this issue in more depth, because we had heard from the tribe numerous times.
Miss Forsyth, I'm hearing a lot of me, I.
Dr. Curdy, Ms. Forsyth gets to respond to your question. So are you done, Ms. Forsyth? You're welcome to finish your response here.
I'm done.
Okay, thank you. Dr. Curdy, now you.
So questions around consultation. If CITES, as it stated, holds confidentiality concerns of the tribe seriously, why did CITES not disclose to CICC that they would not be limited by confidentiality requests when they shared the letter with their consultants and legal counsel, and when the tribe explicitly in the April 18th consultation and the May 3rd letter stated that this could not be shared with consultants without free, prior, and informed written consent of the tribe?
Objection asked and answered. She got advice from legal counsel. She explained the limited release.
I think we have one more
question. I asked a different question, Mr. Ferguson.
What was that, Dr. Curdy?
If CITES holds the tribe's confidentiality concerns and seriousness, why did they not make the reasonable effort to inform the tribe that any letters provided could not be held in confidence?
All right, so let me rephrase.
Yes, please.
And I'll try. If the authority represented to the tribes that it could, or why didn't the authority clarify to the tribes in advance that they may share this information in these letters with in a limited way with their consultants?
I will say that we did not share that with the tribe. Frankly, because we felt that consulting with a limited team under the request of confidentiality and including our attorneys to ensure that request of confidentiality was within the authority's purview to respond to this letter. It was myself, Mr. Brown, and Mr. Spessert, who had been involved in the tribal consultation pieces of the project and in direct meetings with Calusa. And we need additional folks to help us think through these items and make adjustments to the project. We didn't share it probably because more so that we felt that we would likely get a very strong reaction from Dr. Curdy, but that we needed to consult with our attorneys and our
Dr. Curdy.
This is important. I work
Dr. Curdy, that's enough.
I work with and for the Calusa tribe. It's dismissive to continually put this on me.
Dr. Curdy.
Yes.
Enough. Ms. Forsyth gets to answer. We treat each other with respect. You get to ask your questions. Those are the rules. Ms. Forsyth, you can finish your answer if you have more.
I think I've concluded. Thank you, hearing officer.
Hearing officer, I think it's important that it's disrespectful to the tribe when reference is made to me rather than the tribe's concerns. Is that fair?
I think that it is a heated moment, and I'm considering whether we all need to take a break. But I would like you to be able to ask your questions because I know you have a conflict tomorrow.
Yeah.
Let's move forward.
How did you consider the Calusa tribe's ceremonial seasons in their ability to respond to consultation requests?
Objection lacks foundation.
Can you provide a foundation, Dr. Curdy? Try the question again. I'm sorry.
Yeah. There were statements earlier that the Calusa tribe did not respond at certain times. For example, within the context of geotechnical consultation letters. This was during the tribe's ceremonial season. How did you take this into account in terms of good faith, meaningful, and reasonable attempts at consultation with the tribe?
Objection assumes facts, not in evidence. We don't know anything about the tribe's ceremonial seasons. There hasn't been any evidence introduced.
Let's, I'm going to rephrase the question with, did you consider, Ms. Forsyth, did you consider in the timing of the responses from the tribes any traditional holidays or cultural ceremonies that might be occurring?
We did not consider those. However, I will say that, as I testified earlier today, even if the tribe had missed the 30 days under AB 52 consultation, we continued to work with the tribes on a more of an informal outside of AB 52 basis. And I think that's demonstrated by the 2022 to 2024 geotechnical efforts.
Ms. Forsyth, what is your knowledge base to make determinations around tribal affiliation?
I'm not sure I understand the question.
We've heard from you, and the question will be passed on to Ms. Reese as well. We heard that the site's project authority repeatedly made determinations around affiliation to the project area. What gives you the knowledge base to be able to make these determinations?
The authority consulted with the California Native American Heritage Commission with regard to the project footprint. And then the authority also has a number of individuals who have worked with tribes in California who help it review the information from the Native American Heritage Commission and think about whether that is inclusive or exclusive, or if additional tribes need to be added or not to that effort.
So I think it's important to once again ask the question, did the Calusa tribe repeatedly and consistency relate to you that no project personnel that you had working on this were able to validly and soundly speak to tribal concerns, to account for tribal relationships, to account for impacts to tribal cultural resources?
Objection asked and answered.
Is your question, Dr. Curdy, with respect to the particular employee's authority to make representations on behalf of the tribe? Is that the nuance here? I think, so that's fair. Go ahead, Ms. Forsyth.
So we heard those concerns expressed from the tribe repeatedly, I think is fair. The authority looks carefully at its team to consider the qualifications of those individuals. They are all well qualified within their field. I think AB 52 is clear that the experts are the tribes themselves, and we were working to engage the tribes to provide that feedback and that information so that we could include it as appropriate in the documents.
Before the April 18th consultation, during the April 18th consultation, and in the follow-up May 3rd, 2023 consultation letter, did the Calusa tribe provide pathways that the tribe understood as possible to develop collaborative practices with sites in order to accomplish these responsibilities, to take a hard look at impacts to the environment as understood by the tribe?
I believe the only pathway that I understood and saw from those letters was to hire a specific individual that was recommended by you, by the tribe, excuse me, that was recommended by the tribe. The authority looked very carefully at hiring that individual and understood that that individual had a personal relationship with Dr. Curdy and felt that there was a potential ethical conflict in hiring that individual. Ultimately, the organization that that individual worked for identified that the authority was interested in bringing that individual on irregardless, because of the nature and difficulty in the conversations. And I felt that whatever we could do to try to make the conversation better would be good. The firm that that individual worked for ultimately identified that individual as not being allowed to work on the sites project because of conflict issues.
And the understanding was the conflict was that we had a personal and professional relationship.
That is something that the firm would need to speak to. All we understood, because it is not appropriate for us to get in the middle of topics between consulting firms and their employees. All we understood was that there was a personal relationship.
And was this not part of the concern raised by the tribe that your consultants were actively working in ways to undermine and leave out tribal concerns?
I guess I fundamentally feel that if a consulting firm with their own legal department has taken a hard look at this and feels the individual has a conflict because of a personal relationship with you, Dr. Curdy, that I leave it to the consulting firm to determine that.
Which legal counsel was conferred with regarding the consultation confidentiality issues?
The authority's legal counsel for the EIR is an organization called Perkins Coie.
Perkins Coie. Okay. Miss Reese, how long have you worked for HDR?
14 years now?
Have you ever observed an HDR employee removing information regarding tribal concerns? In
Objection, relevance, and
the relevance is that this is an ongoing concern of the tribe, and this was relayed to the Sites Project Authority repeatedly, that their consultants were not capable of fulfilling their responsibilities. This speaks to the discussion around information consideration, around how it informed the no project alternative.
Dr. Curdy, but tie this back, please, once again, to the hearing issues, because the EIR is not actually
Okay.
one of the, right. We're
Okay.
discussing the issues in the water code.
Right. Dr. Kinsey, the hard thing is the EIR is repeatedly referred to and depended on for findings.
I understand that. So certainly it is relevant.
Yeah. So that was one pathway. Did the Calusa tribe not offer you the possibility that the tribe would provide language speaking to the tribe's relationships and concerns and the impacts that would occur with no revision and no modification? Was that not offered to you and as a representative of Sites Project Authority on April 18th?
objection, beg, revisions, revisions to what?
That the statement given by the tribe would go in as written by the tribe with no modification or revision in the EIR. Was that offer not provided?
And who is the question to? I'm sorry, Dr. Curdy.
Ms. Forsyth. Ms. Forsyth. Yeah.
That is correct. The tribe did make that request at the April 18th meeting. I believe the record shows that the authority requested that statement a number of different times from the tribe, and that statement was ultimately provided in October at a time frame when inclusion of that statement into the final EIR was not possible because we were already in final production mode of the document. So we included that statement, and the authority's response to that statement in the board packet for the certification of the EIR so that it was fully disclosed to the public and to our board members as part of the CEQA process.
Ms. Forsyth, can you point to where in the record you had requested that statement?
I cannot offhand, but I am fairly confident that it is in one of our letters. Actually, it is at least in our October. Oh, what's the date of this letter? Sorry. It is definitely in our October 20th letter. I'd have to look back at previous letters to see if it is reflected in those letters also.
Ms. Forsyth, I believe you're going to find that it is not. There was not a request made for that statement.
Dr. Curdy,
yes.
This is not the time to testify.
Okay, sorry.
Questions.
Again, I'm not a lawyer. I'm trying to navigate this. Please understand. When did Sites Project Authority first respond in writing to the tribe's May 3rd, 2023 letter?
The exact date, I'm confident through our discussions with the tribe that it was 4 months, because we have heard numerous concerns over time as to why it took us 4 months to respond to the letter. I will say that it took us time to really think through these items and think through carefully what we had heard from the tribe. It was also I will say that since I was involved in the meetings and in the consultation efforts, I generally drafted the responses. It was also a time when I was having some health issues and had been in and out of the emergency room a number of times. So it took us a little bit longer than we had anticipated to respond to that letter.
So my understanding of this timeline, Ms. Forsyth, is on the April 18th, the tribe provided at least 2 good faith pathways to be collaborative on this project and to account for tribal concerns in the EIR and to address the EIR with the best available information. Per your testimony, Sites Project Authority did not respond for approximately 4 months. I believe it was a little over 4 months. Then, in your testimony, there was statement that when you asked for that information from the tribe that was offered on April 18th, the statement to go into EIR, it was not until October 20th. The tribe provided you that documentation on October 27th, a week later.
He's testifying. I'm sorry to interrupt, but we need a question.
Yes, correct. Dr. Purdy.
Yes. So the question is, how did you then make the statement in good faith, meaningfully, and reasonably when the only time you can identify as you actually making that formal request was only a week before the tribe sent it in?
Very comfortable testifying that I asked verbally at meetings with the tribe. I cannot specify exact what meetings because there were a number of them that happened in 2023. I would need to look back at the letters to see if we had requested in writing previous to that October letter. But it is something that we were thinking about and that I had verbally asked the tribe for in one of our consultation meetings, knowing that the window was closing. I also want to just correct the record. You identified that the tribe had provided the authority with 2 pathways to meaningful consultation. I believe we have only discussed one individual that the authority had proposed, or excuse me, that the tribe had requested that the authority employ. I'm not sure we had discussed a second pathway.
May I clarify, Dr. Kenzie?
And it's I'm not a doctor, so
I'm
hearing
sorry.
officer is fine.
I'm sorry.
No, Dr. Curdy, this is your chance to ask questions. On rebuttal, you have a chance to respond to any of this evidence that's being presented.
Okay, thank you for providing clarity there. Did we not, in fact, discuss 1, an individual that the tribe trusted, and 2, that the tribe would provide a statement? Are those not 2 pathways?
If those are the 2 pathways that you were referring to, then yes, I understand.
Okay.
Yeah.
Okay. You had stated that based on Calusa Tribe's concerns, that you led a study to understand the relationships, the potential TCRs of the tribe that are there. What are your qualifications to lead such a study?
I did not lead a study. I bring individuals together and have discussion and dialogue with their input and their expertise and make management decisions and recommendations to our board with that information.
Was Ms. Reese one of these individuals?
At times, yes. We also have other individuals from ICF and individuals, an individual that is a subcontractor to ICF.
Just to be clear, the tribe made clear on numerous occasions that they could not accomplish what needed to be accomplished to address the EIR by any of these individuals. Correct?
That the tribe made that clear. And I think I'd like to say that consultation is a 2-way street here. There is dialogue that goes back and forth in this. And so the authority had a team, looked carefully at that team. What we heard from the tribe was there is one individual that we trust, that we can provide this information to. We pursued involving that individual, and there was a conflict there. I think it's important to note that the OPR guidance calls tribal consultation a back and forth and a sharing between both agencies.
Ms. Forsyth, I find it curious now that you're referring to OPR guidance. Are you saying you did follow OPR guidance?
With regard to the technical advisory on AB 52, I believe earlier I understood you to be referring to different OPR guidance, not the AB 52 technical guidance.
I am referring, and I was referring then to the AB 52 technical guidance.
We did take a look at the OPR's June 2017 technical advisory on AB 52.
And does that technical guidance also point to tribal consultation guidelines from November 14th, 2005, and that those should apply to OPR guidance on AB 52?
I don't recall specifically.
It does. So if I'm to understand correctly, you picked and chose what OPR guidance to follow and not follow?
Objection, argumentative, and yeah.
Okay. Can you explain to us what OPR guidance you chose and didn't choose?
Objection beg.
Okay, I'll move on with this. So I have a question for you, Miss Forsyth. Is Young and Wooldridge a council to the Sites Authority and the Colusa Groundwater Authority?
Young Wooldridge is our general counsel. I cannot speak to their other clients.
Okay. If they were, or is this going to be speculative? Which legal was, again, I want to ask again, which legal counsel was conferred to with regarding consultation confidentiality? Was it anyone from Young and Wooldridge?
My first inclination is to say discussions between clients and attorneys are privileged.
Okay.
In this context, I will say that I consulted both Young Wooldridge and Perkins Coie.
Okay, so previously you said Perkins Coie, so I'm understanding correctly, you also consulted Young and Wooldridge on this matter.
Dr. Curdy, where are we going with this? We seem way off how does this relate to our proceeding here?
They were saying the same, and it's so funny.
Sorry, was someone else saying something?
I think I think we're okay now.
Okay, I'll move on. In your testimony and in the EIR, you stated that you consider the TCR as identified eligible. Is that correct?
I'm sorry.
Objection beg.
In the EIR and in your testimony, you stated that you have considered as an agency identified TCRs to be eligible for the CRHR. Is that correct?
AB 52 identifies and has specific code sections on defining tribal cultural resources. I believe they're in section 21074A, and it specifies that it has a number of things, but they including or determined to be eligible for inclusion in the California Register of Historic Resources. Also potential local registers of historic resources, or as determined by the lead agency in its discretion, and supported by substantial evidence to be significant
Mhm.
pursuant to criteria set forth in following sections of the Public Resource Code.
Okay, now this brings us back to the matter of the OPR guidance and the OPR AB 52 guidance. So you stated that you did address, or you did take into account the OPR guidance on AB 52, correct?
That is correct.
Okay. So in making these determinations, so as it states, and I believe this has been put into the record, this document, it's on page 5 of 15 of the PDF.
Yeah, can we bring that document up, Dr. Curdy? Sorry for interrupting.
That's okay.
I don't know what document you're referring to.
It's the AB 52 Technical Advisory from February 2020 by OPR.
Is it submitted as an exhibit in this proceeding?
Yeah, Miss Willie referenced it, and I had sent it in earlier, so it should be the one I sent in. I can give you the file name.
Great.
Yeah. It's 20200-AB_52_ technical. I don't know if you need the rest or if that's enough to bring it
That
up.
might be enough.
Okay.
I'll look to my team. There we go.
Okay.
And then what page was it? Well, let's scroll down so we can identify the document here.
Yeah, it's page 5 on the PDF. If you search PDF number 5 out of 15, I'm not sure of the actual written number. Yeah, that should work. Okay. Evidence that may support such a finding could include elder testimony, oral history, tribal government archival information, testimony of a qualified archaeologist certified by the relative tribe, testimony of an expert certified by the tribal government, official tribal government declarations or resolutions, etc. Did not the tribe repeatedly, through repeated declarations, tell you that this was a National Register eligible historic district, that it was a California Register eligible defined cultural landscape? In April 18th, was this not first conveyed to you from the tribe formally?
Objection vague with respect to that.
The eligibility of this, if we want to call it a tribal cultural resource or property of traditional religious cultural importance, depending on the regulatory regime we're talking about.
But which resource on the ground are you talking about?
I'm talking about the defined cultural landscape that envelops the site's project area. I'm talking about the historic district that envelops the site's.
Hold on, Dr. Curdy. This is where it's too many things. One thing at a time, please.
Okay. Under CRHR, it's a defined cultural landscape. Under the NRHP, the property type would be a historic district.
What is the question?
The question is, did not the tribe, in a formal letter in April, identify this as a California Register eligible defined cultural landscape and National Register eligible historic district?
And what is this?
The historic property that envelops the site's project area. The entire site's project area.
Okay, let's stop there. I'll allow that question. Ms. Forsyth.
Tribe on a number of occasions identified a tribal cultural landscape. I would have to look back to the record to refresh my memory on whether the tribe identified it as being eligible for the California Register of Historical Places or a local register. I think what we're working with here is that there is a difficult tension between the statutory requirements of AB 52, which identify that tribal cultural resources, as I stated earlier, need to be certain things that are determined eligible for the California Register or included in a local register register, or resource determined by the lead agency and supported by substantial evidence to be significant. There's a tension between following those statutory requirements carefully because we are in a CEQA document. And although the tribe may feel that we should have recognized it, we have to carefully follow the statute, because someone in opposition to that could litigate us. So we need to be careful in following what AB 52 says. And there's a tension between that and the fact that the tribes are the experts on their resources. And we fully understand that tribes at times and with respect to certain resources don't want to disclose them, can't disclose them for cultural and traditional practices. And so trying to figure out how to balance this tension is something that I think is challenging for a number of agencies. We chose to balance it by following the statutory requirements of AB 52 from our perspective.
Ms. Forsyth, is consultation, government to government consultation, a legal responsibility of a tribe to a governmental entity?
I have no idea. I don't understand the question, really. I mean, you asked, do tribes have to consult?
Is it their obligation to consult?
I don't think it's their obligation to consult. Tribes are obviously can submit comments on environmental documents as organizations without being in AB 52 consultation. I don't believe they're obligated to consult.
Are state agencies obligated to consult? State, federal, local agencies under various laws and regulations, including AB 52.
Objection vague. Relevance.
Where are we going, Dr. Kurdi? I think we can look up the legal requirements on our own, but
yeah, where we're going is consultation is a legal obligation from a governmental entity to a tribe, not from a tribe to the governmental entity.
Let's move on to the next topic then. Okay. I think that can be established separately.
Whose responsibility is it to fulfill compliance with CEQA and AB 52?
It is the lead agency.
Asked and answered.
Okay. Yeah, it's the lead agency. So,
and I will say that compliance has been completed and has not been disputed in a court.
Let me ask this. If your compliance has been completed and you're confident that you have consulted meaningfully in good faith and reasonably with the tribe, how have you accounted for the as what the tribe has identified as irrevocable impacts to their cultural landscape?
We thought a lot about this in finishing up the EIR, and I think I would need to refresh my memory. Sorry, let me get to the right attachment here. I believe that the authority provided its thoughts on this in Cites 96, where we responded to that October 27th letter from the tribe. In that letter, it's in Cites 96. And what we generally identified, it's been a while since I've read this, so I'm recalling this from memory, and I haven't read this letter since probably the November 2023 timeframe. But if I recall correctly, the authority felt that through the mitigation measures that we have identified in the EIR, that we would do our best to avoid impacts to tribal cultural resources, including the tribal cultural landscape, but felt that by the nature, just the sheer nature of a tribal cultural landscape, the impact to it would likely be significant and unavoidable.
So now with that understanding, you agree that the Calusa tribe has conveyed on numerous occasions that the impacts will be irrevocable, correct?
I believe that the tribe has expressed that the authority has identified those impacts as significant and unavoidable.
Okay, but you do understand, per your own testimony and per Ms. Reese's testimony and per Mr. Ferguson's statements, that none of you have the authority or the knowledge base to make these declarative statements the way the tribe does.
Dr.
Yes.
Curdy, I think we're getting to the end of I mean, this is important and I understand, but I think we're going around in circles on the same issues at this point. I think I've heard a lot of testimony from Ms. Forsyth, but we're coming back to the same issues. So
Okay.
let's move forward. There's very clearly a disagreement and you will have your chance to highlight.
Okay. With that understanding of the tribe's position of what will occur if this project goes through, why is it that Sites is asking for all of this water exceptions and all of these water rights from the water board?
Objection vague.
It is vague, but
Okay, I'll ask it again.
Okay.
With this understanding of the tribe's position on what will occur, why is it that the Sites Project Authority is asking the Water Sources Control Board to accept a petition for partial assignment of state filed application 25517, accompanying water right application 25517X01, and petitions for release from priority of state field applications 25513, 25514, 25517, 22235, 23780, 23781 in favor of water right application 25517X0 filed by the Sites Project Authority?
I think the authority board identified in its statement of overriding considerations, along with its findings on the EIR, that it believes, as the board of directors of the authority, that the benefits of the Sites Reservoir project are important and override those significant and unavoidable impacts. I think that the authority board's findings, CEQA findings, also express a desire to continue to work with tribes throughout the life of the project, to include them and represent them in ways that are meaningful from the tribe's perspectives.
Do you recall during a consultation meeting, the site's executive director, Jerry Brown, stating that if this site's project is not financially profitable, it will not be further pursued?
I recall that, and that is something that's pretty foundational.
Okay. So my understanding is you're saying the Sites Project Authority's position is that the monetary profit of this project is more significant than the cost it'll have to tribes, particularly the Calusa tribe?
Objection misstates testimony.
I think you can ask that question a different way without what you are saying is part of it.
Okay. Is it the position of the Sites Project Authority that financial profit from this project is a significant factor, whether it'll go through or not, that is more significant than what the cost will be to tribes?
That is not the authority board's position.
Can you share then in reference to the statement you agreed to, that it's pretty foundational that there has to be financial profit, how tribal costs are weighed against that profit and that foundation?
What I understood you to ask earlier, and maybe I misunderstood, was that Jerry Brown's statement was that the project has to be financially viable. To us at the authority, that means that the costs of the project need to be balanced with how much water people will receive. So if the water is too expensive, they're not going to want to invest and participate in the project. So when we at the authority talk about financial viability, we are using that in reference to continuing to ensure that the water from Sites Reservoir is affordable for its members. Not that there's financial profit out of the reservoir.
Can you tell us who Gary Evans is?
Gary Evans is a supervisor with Colusa County, and he sits on our authority board of directors.
Was Mr. Evans, did he participate in a government consultation meeting with the Colusa tribe?
He did join a meeting, yes, with the authority and the Colusa tribe.
How long did he stay?
I believe Mr. Evans left that meeting relatively early. I cannot speak for him, but he expressed to us that he felt the conversations from yourself, Dr. Curdy, were unprofessional. And was not interested in continuing the dialogue.
So with that understanding, Mr. Evans voted in favor as a board member for this project, correct? Approval?
Dr. Curdy, I think we're straying off track here again. How is this relevant to our proceeding?
Yeah. I think it's relevant because it once again goes to how the tribe has not received attention or representation or consideration throughout this process, and how it speaks to water, fish, as cultural resources that have continually, through different procedures and different activities, marginalized the tribe.
Well,
So
we're attempting to
okay.
provide an opportunity to bring some of that in, but I think let me ask this: we're at 4:52. We're approaching the end of our day. How much longer do you think you have in cross-exam for Ms. Forsyth? I wasn't clear to me whether you can come back in the morning at all. What is your status on cross-exam?
I can come back. I'm not certain if the tribe can come back, and there's moments where they might want to interject as well. I'm speaking in their interest to their concerns. I'm an employee of the tribe. But the executive committee may want to speak to some of these concerns as well as part of this questioning. Let me see. Well, we're waiting potentially for a response. I know we have till 5. Ms. Reese, you said you did background research, correct?
Hold on, Dr. Curdy. So how much longer do you think you don't know?
Because it's not only me speaking for myself, right? So I just reached out to the executives to try to identify additional time that may be needed.
How about just speaking for yourself? How much time do you think you need for the questions that you have?
Ms. Kenzie, it's hard because a lot of these questions are emergent off what the responses are. and the response is very off, right?
I
You get what-
recognize that. I know, and I ask all the attorneys the same question, and I don't necessarily hold them to a strict accounting. I'm trying to make a schedule for tomorrow.
Okay,
So
okay.
are we talking an hour or 5 more minutes? How about something in a ballpark?
Let's say an hour in the morning.
Do we have substantial additional questions?
Substantial additional questions. And I think one question perhaps, that'll take about 5 minutes that we can close on. So Miss Reese, did you do background research for this project?
I did not do background research myself. Other consultants did.
Ms. Forsyth, can you explain why those consultants were not selected to testify in this hearing?
There were a number of individuals that contributed to the tribal cultural resources section and the cultural resources section. And those different folks had touched it at different times because we had asked for review of the section multiple times when we were hearing concerns from Calusa in 2023. It's just not feasible to have a dozen people testify. And so we asked Ms. Reese to take this effort on.
Ms. Reese, you said you've worked in cultural resource management, archaeology for quite a while, correctly? Correct? Correct. Are you familiar with Alfred Kroeber's Handbook of the Indians of California from 1925?
Yes, I am.
Yeah. Do you know if this handbook was consulted at all by any of the folks working on cultural resources?
Yes, I believe we cite it in the cultural resources chapter.
Okay.
And maybe the tribal resources chapter, I'm not sure.
Yeah. Can you tell us what type of archaeological concepts and methodologies were applied to this project?
Objection vague.
That is vague. What do you mean by that, Dr. Curdy?
Okay, let me ask specifics. Were the conceptual and methodological approaches inclusive of indigenous archaeologies?
We did not specifically in the development of those chapters review anything that was called an indigenous archaeology. No.
How about archaeologies of landscape?
I don't believe that the consultants developing the chapters looked at or included anything that was called archaeology of landscapes.
How about landscapes of place?
I believe our consultants reviewed the National Register of Bulletins related to archaeological resources, and of course, National Register Bulletin 38 related to traditional cultural properties.
What about landscapes of movement?
I have not heard of that term.
Okay, it's been emerging for quite a while in archaeology.
Dr. Curdy, this is not the time to testify.
Sorry.
And we have 3 minutes, so I'd like to stop us here because we're at a point.
Dr. Kinsey, or sorry, Ms. Kinsey, can I raise one quick matter on this, just that we can close with? Is that possible?
One more question? Is that what you're asking for?
Yeah, one more question.
One more question.
Okay. So are you familiar with the Advisory Council on Historic Preservation Indigenous Knowledge Policy?
I am aware of Indigenous knowledge information. I have probably looked at that at some point in the past, but I couldn't recall anything exact about it.
Okay, last question.
Dr. Curdy, that was it. You
Okay,
had plus one already.
I'll pick up with
Pick
this
up in the
tomorrow.
morning.
Yeah, I'll
It
pick
is
up.
4:58 p.m. I am serious about the hard stop at 5.
If I asked a question I wanted, it would have been compound. So I'm trying to learn.
Right, I know you did a fine job.
Okay, thank
I will see everyone in the morning at 9 o'clock. We'll pick up where we left off. Thank you, Dr. Curdy. Thank you to the other cross examiners. Thank you, Ms. Forsyth, and thank you, Ms. Reese. And we'll pick up at 9 a.m. Thank you. We are
Thank you.
adjourned for the day.